If you're remarried and you have children from a first marriage, or your spouse does, I need you to hear this. Colorado law does not protect your children the way you think it does. Not because anyone did anything wrong, because the law defaults to a structure that was written for a different kind of family than yours. Here's what most people don't know until it's too late to fix it easily. Under Colorado law, stepchildren have no automatic right to inherit anything from their step-parents. Not a portion of the house, not a share of the savings, nothing. It doesn't matter how long you raised them, how close you are, or how certain you are that, of course, they'd be included. If there's no will, or the will doesn't name them specifically, they're left out, by default, by law. And here's the part that surprises people even more. A surviving spouse can claim up to 50% of marital property, even if the will says otherwise. So picture this. A husband wants his first marriage children to inherit the family home. He writes a will. He remarries. He never updates that will. He passes away first. His new spouse can still claim half of that marital property, regardless of what the will directs. Nobody planned for that outcome or meant for that to happen. It happens because Colorado's default rules take over wherever a plan doesn't say otherwise. We hear a version of this fear constantly. Never rely on the surviving spouse doing right by the biological children. Spouses are generally trustworthy, that's not the problem. It's that circumstances change. People remarry again. People move. Life gets complicated, and verbal promises don't hold up in probate court. So, what does protect your family? First, name every child specifically in your estate plan. Not my children as a category. That language can create ambiguity between biological children and stepchildren. Name them. Say what each one receives. Second, consider a trust instead of relying on a will alone. A will goes through probate court, where a judge and default statutes fill in any gaps you leave. A properly funded trust lets you control distribution directly, who gets what and when, without the court deciding for you. Third, revisit your plan after every major family change. This might be a remarriage, a new stepchild, a new grandchild. Any of these should trigger a review, not a, we'll get to it eventually. This isn't about picking sides between a spouse and children from a first marriage. It's about being specific enough that nobody has to guess and nobody has to fight about it later. Families we've worked with describe this same fear before they act. Family homes sold, step-siblings at odds, promises broken, not through intent, but inaction. The plan is what turns we assumed into we made sure. If you are a blended family and you've never had your estate plan reviewed specifically for how Colorado treats stepchildren and spousal claims, that's the conversation worth having. You don't need to have all the answers before you call. Start with a simple conversation. We'll walk through your specific family structure and show you exactly where the gaps are and how to close them. Now, if you're not in a blended family situation, but you are the one who's going to be responsible for handling a parent's estate someday, you're probably wondering something different. How long is this actually going to take? In the next video, I'm walking through the real Colorado probate timeline, month by month, so you know what to expect before you're in the middle of it. If you found this useful, please like, subscribe, or share it with someone you care about, and I'll see you next time.